Ladies and gentlemen, justice, it seems, often needs rescuing from the very courts entrusted to uphold it. And once again, it was the Supreme Court of India doing the rescuing. The apex court has stayed an Allahabad High Court ruling that had shocked the country by downgrading a heinous sexual assault on an 11-year-old girl in Uttar Pradesh. The High Court had held, rather controversially, that grabbing the child's breast, breaking her pajama strings, and attempting to drag her under a culvert did not constitute attempted rape. Instead, the court said it was merely aggravated sexual assault under the POCSO Act, which carries a lighter sentence. Just for context, ladies and gentlemen, the court had delivered its verdict 4 months after reserving it. So it delivered its verdict after applying its mind. This was not a blooper. The Supreme Court was not impressed at all and was having none of it. A bench led by Justices B.R. Gavai and A.G. Masi took suo moto cognizance of the ruling following public outrage and a petition by a women's group. The Supreme Court's verdict? Well, they said the judgment was nothing short of shocking. Not a hasty decision, but one deliberated over for 4 months, making its twisted reasoning even more alarming. The court slammed the lack of sensitivity, calling it an inhuman approach, illegally unsound, and completely unacceptable. These were some pretty harsh words from the Supreme Court today. But here's the real question, ladies and gentlemen. Why does the Supreme Court have to keep stepping in to undo the damage done by lower courts? This isn't an isolated incident. Just last year, the very same Allahabad High Court directed a university to determine if a rape survivor was actually a manglik, as if astrology has anything to do in a court of law. The Supreme Court had to stay that order, dismissing it as absurd. Then there was the Calcutta High Court and its regressive remark. Adolescent girls, said the court, must control their urges or be seen as losers for giving in to 2 minutes of pleasure. The Supreme Court didn't just overturn the ruling, it called out the mindset behind it, labeling it objectionable, unwarranted, and perverse. Ladies and gentlemen, these aren't just legal blunders. They happen way too often. They expose a deep systemic failure, a pattern of judgments that defy logic, justice, and even basic human decency. The point is, where does the real problem lie? Is it a problem of the quality of judges or the quantity of judges? Is it in how judges are trained? Is it in a lack of accountability? Or is it in an outdated patriarchal mindset that somehow still finds home within the judiciary? Whatever the answer, one thing is clear. Perhaps it's time the Supreme Court did more than just correct these rulings. Maybe it's time it examined the very judges passing them. Because if justice needs saving this often, then something is deeply and fundamentally broken. A chat with my guest this evening, Lalitha Kumara Mangalam is a former chairperson of the NCW, joining us on the broadcast. Nimisha Srivastav is a child rights advocate. She's joining us on the broadcast. Avishkar Singhvi is an advocate at the Supreme Court. Avishkar, thank you very much. And Rizwan Siddiquee is an advocate. He's joining us on the broadcast as well. Rizwan, I'm going to start with you since you're the only one here trying to defend what the Allahabad High Court had said. Rizwan, right. I'm not someone trained in the law. I'm not a lawyer. I have been to a court of law exactly once in my life, and I have absolutely no motivation to go there ever again. Rizwan, I want to ask you, if someone like me who has no training in the law will look at what the court said, the Allahabad High Court said, and say to herself, how is this not attempted rape? What were the judges thinking? If a child, 11-year-old's breasts are grabbed, her pajama strings are untied, she's pushed to the ground by 3 men. Right. If this is not attempted rape, what is?
So to begin with, let me clarify the position right now. Since the Supreme Court, the Honorable Supreme Court, has suo moto asked the proceedings to be taken before the Supreme Court, and the matter is now sub judice before the Supreme Court, I will have very limited to talk about this on public platform or even otherwise, because the matter is now sub judice. On the earlier occasion, the matter was not sub judice, the order was passed. So once the order is passed, then it can be open for public debate. But once the matter is before the Supreme Court, then we as officers of the court cannot do public debate on that subject if the matter is sub judice. So I'll be talking very limited on the subject. The fact remains that any order passed by any court has to be in accordance with the sections and the provisions of law. Now, attempt to rape. Attempt to rape is not a codified section. Attempt to murder is. But attempt to rape is not a codified section. There is no section called attempt to rape. There could be rape or there could be sexual assault. So if there is no rape, then the provisions of rape cannot be used. I understand the sentiments of the public. I understand exactly that this is a matter which would hurt public sentiments, that how can a man get away with such a serious and a heinous offense? But nonetheless, the law of the land does not have a codified section regarding or dealing with attempt to rape. There could be rape, there could be outraging modesty, there could be insult to modesty, there could be a POXO provision, but attempt to rape is not a codified section. So now, therefore, keeping all these things in mind, and now also keeping in mind that the matter is sub judice before the Supreme Court, so I should think and talk what I'm talking. So therefore, and I'm the only man who's, not talking like others. So I would only limit myself to this particular provision because I would really want to see what the outcome of the Supreme Court judgment would be in this particular case. So my only defense
so would I, but what the Supreme...
So
go ahead.
Only thing that I would like to clarify is that when there are codified sections, no judge can travel beyond those sections. So I can understand that you could remove those sections or you could add sections. But when there is no such section that can be added, the judges also can't do anything about it. I understand every judge will have his own way of looking at a particular case. If he has adjudicated on the matter, he's heard the arguments from both sides, the state, the victim, or any other party involved. So he's a better person to pass an order keeping in mind all these things. And if you look at this case, the judgment was passed.
But Rizwan, the courts in this country, and judges in this country are not lakir ke fakir, right? There is the written word, and then there is how you apply the law.
See, if
I'm thinking to myself, if three men grab a little girl's breast, untie her pajama strings, push her to the ground,
right?
How is this not attempted to rape? That rape would have happened had the passerbys not heard the girl scream and rescue her. और यहाँ पे तो application of mind हुआ है ना, Rizwan? The court reserved its order for 4 months. They deliberated upon it and thought about it for 4 months. Matlab, does it even require law to tell you what this was? Because to me, this is plain, simple logic.
No, I'll tell you how it works. If you look at the sections, the provisions, and the judgments which have been delivered by the Honorable Supreme Court from time to time, have made it very clear, very, very clear that in this particular case, let me talk about this particular case. In this particular case, the preparation part that they had prepared and they had attempted to rape is something which is under debate here. That is the part which is being debated here. So that is something which is a very touchy subject because the High Court had a different opinion about this, that the High Court said that there was no such attempt and it happened in a regular routine manner. That is the only difference that we see from the Honorable High Court and the Supreme Court's version. Because that's the difference. Because if you look at the order, that was passed, we have to look at what weighed on the judge's mind. What was the judge thinking? What was the honorable judge considering? Which particular provision of law did it take into account? Which part did he not take into account? That can be subject to debate because that is all within the legal framework. But I'll tell you what happens in a case like this when we are arguing on a point which is attempt to rape, inverted commas, attempt to rape. There is nothing called attempt to rape. Either there is rape or there is no rape. If there is no rape, no penetration, then there are other provisions. Then there are other provisions which will be applied here. The only thing is that when the judges write orders, when they author orders, they have to be sensitive with regards to the words that they use in a case which is before the public forum. So all judges have to keep in mind the
Okay.
words, the language, the framing of sentences which could hurt somebody. So that is, I think, what is being shown here, that there
Okay.
was no sensitivity. Yeah.
Okay, would Avishkar want to come in? There's a legal point that Rizwan is making, Avishkar. He's saying under Indian law, there is nothing codified as attempt to rape. And therefore, if the judge says this wasn't an attempt to rape, legally he was correct, perhaps. But that is not what the Supreme Court is saying. The Supreme Court is saying it lacked sensitivity, it lacked a human approach, it was legally unsound and completely unacceptable.
Hi, Shreya. Thank you for having me on the show. Firstly, I'd just like to say that the conduct and the order of the judge, I would echo the sentiments of the Supreme Court with regard to the order of the High Court, because it is totally shocking, reprehensible. It is despicable, and I am at a loss for adjectives to describe the order. Uh, as regards my friend's, interpretation of the fact that there is no codified section of attempt to rape, I just want to tell him that there's a judgment of the Supreme Court itself in Mahindra, which specifically says that anything after preparation, any stage after preparation, is attempt to rape. And that has been judicially recognized. Point number one. Point number two, in the new BNSS and the new sections of the new code in the IPC, section 74 onwards, specially recognize assault of criminal force with women with an intent to outrage their modesty, sexual harassment, etc., and assault with intent to force. So there is a clear array of sections which recognize such offenses. This offense cannot be explained by simply saying that there is no attempt to rape in the facts of this case. After recording the facts of the case, which included, as you had already described, I don't even have the gut to say them on television, but after recording those facts, the judge could not have come to a conclusion after application of mind that that does not constitute attempt to rape. The Supreme Court, in the decision in 2022, it's a fairly recent decision, which says that after the stage of preparation, anything that is done after the stage of preparation would be construed as an attempt to rape. So therefore, there being anything, and in this case, it is very clear that if you're grabbing, if you're doing all of those things, those are clear attempts, and therefore, even if you're not convicting under rape, you can convict under the lesser offense. In the new act, this has been specially codified to answer my friend's question. But the second point is, one is the legal aspect of this whole case. The other aspect is this aspect of showing compassionate sensitivity to such cases. That is another aspect of this case, because judges are human beings ultimately, and the Supreme Court has, of course, done great damage control in this case by coming down and sort of controlling the situation. But I would still say that there is a need in our system to be able to sensitize judges and to be able to explain to them that in each and every situation like this, they must be very careful with their word, because the judiciary in our country only inspires confidence because of the manner in which it writes and the manner in which its judgments are construed by the public. Today, the people in this country, and in fact, this is an additional thing. Today, Justice Oak of the Supreme Court, in his speech, has said that there are a lot of citizens who do not inspire, who are not confident in the judicial system. So things like this are very bad, and they are very sad for our system to be seeing such orders. There is the Calcutta High Court, there is the Bombay High Court. There, I can show you many such instances. These are of either a cultural issue or a prejudicial mindset, or an attitude towards women. I don't know what it comes from, but it is certainly a endemic problem which needs to be curtailed.
Lalita, Avishkar is talking about the people's faith in our judiciary.
Yes.
If lower courts deliver verdicts like this, where is that faith? And why is it that every time the Supreme Court has to come to the rescue? Is this the first time the Allahabad High Court has come up with a verdict that has stunned everyone? No. You remember what had happened last time? A couple of years ago, they had asked a university to actually determine if a rape victim was a Manglik or not.
Yes.
And there are a string of such judgments, not just from Uttar Pradesh, but from West Bengal, from Andhra Pradesh, from all over the place. My point is, how are the people of India going to have any faith in the lower judiciary if one after the other they are passing judgments like this?
Shreya, I'd just like to say here that it's not just the lower judiciary Indians are losing faith in, it's the judiciary per se. There are two big problems with the judiciary. They're just not held accountable. They are accountable to nobody. And what price a democracy if the courts are not accountable to the people? After all, their salaries, everything are paid by our taxes. And when they turn around, and women pay as many taxes as men, there's no gender bias in tax, right? So when they turn around and give such horrible, inhumane, I mean, I'll go on and on with words about it, judgments, of course, we've already lost faith. We're not losing. Most women in this country don't think they will get justice. Justice is delayed. Justice is skewed. Justice is prejudiced. It's openly patriarchal. And we don't even get an apology. Yes, the Supreme Court steps in most of the time, tries to undo the damage. But it's ridiculous. It's much more than ridiculous. It's pathetic. What price is Indian democracy when our courts are so bad towards women? And I'm using very gentle words. I don't want to go into very, graphic words or terms. Unfortunately, there is no judicial system where you give an exam and then you become a judge and you get training, etc., like our bureaucrats. Not that our bureaucrats are doodh ka dhula either, but at least they are accountable. The judiciary in India, and I'm saying this again and again, like it's stuck record perhaps, but it's the truth. And that's what we're all getting so angry about. Look at what happened last week. A judge's house caught fire. And what did they find? A room full of cash. Where did the cash come from? It's come all the way, from God has placed it in his house. They will come up with all sorts of ridiculous theories. Judges should be apolitical. They are not. Judges should not be prejudiced. They're openly not, especially in the case of women. I'm not saying it's only women. Maybe they are prejudiced on some other issues too. Look at the delay in judgments. Nirbhaya took 10 years. And that should have been an open and shut case. The system itself is so skewed. We have a systemic failure in India with regard to justice, of which the judiciary is the most obvious part. People take money and come up with false evidence. There are so many holes in the system that need to be plugged. And here I think the government of the day must step in. It's okay to say that the judiciary is not accountable, but then everybody knows it. The BNS, I'm told, is an improvement of what used to be the Indian Penal Code, the IPC thing, but there still is a long way to go. Both these judges, the one I talked about who had this money in his house and this man in Lucknow, they should be held accountable. Why are they just being transferred and let off? Why aren't they sacked? I mean, come on, what are you going to do to an 8-year-old child if you push her down on
Lalita ji, essentially...
I mean, you want to play football with her? Any idiot knows that they were trying to rape her. And why do we let these judges get off? There should also be public outrage where we demand accountability from judges like this. I wish the NGO that had asked for, gone to court, gone to Supreme Court, also, I don't know if the law allows it. But then if the law doesn't, Parliament should bring an amendment in or something. I know there'll be an outrage and I will be shouted down and, bad mouth and all of that. But in everybody's heart of heart, and every woman in this country, come on, Shreya, even you, people like you, who work, who are independent women, etc., don't we wish the judges are held accountable? Everybody does, but they're not. Till they are held accountable,
the courts are very good at protecting their own.
Yes,
the courts are very good at protecting their own. And if the National Judicial Appointment Commission could improve the quality of judges, baat hi kya hai, but I don't think that will help as well. But I'll come to that question in just a bit. I'm going to get in Nimisha Srivastava as well. Nimisha, as someone who's a child rights activist, actually, as someone who is an Indian citizen, all of us were fairly shocked and aghast with what the Allahabad High Court had said and done. We were wondering what the judge was actually thinking. I mean, it's not like this was a judgment that was passed in haste. The judgment was reserved. There were deliberations for over 4 months, after which it was passed. Today, the Supreme Court had to step in. My point to you is, what do you take away from all of this? Do you take, is it your view as well that our courts are broken, at least our lower courts, that the only court in this country you have some hope from is the Supreme Court of India?
I think I would like to take a more nuanced view here. Our courts are really struggling, but our courts are struggling with a system which makes a lot of things difficult for them as well. I welcome the Supreme Court's observations, and I also, when I read that judgment, I was disturbed by it, and I had all the same thoughts as as have already been discussed on this show. That how is this not attempt to rape? Of course it is. But I would like to bring in another fact over here, because I head an NGO that does work with survivors of sexual violence, and we see these kind of matters in court every day. And as you said, right, that this is not something which is a very unique case. This is happening. And one of the plausible reasons that this is happening over and over again, of course, patriarchal mindsets, yes, but also because, you use that interesting term, lakir ke fakir. Indian judges are not lakir ke fakir. Well, Indian law, particularly recent, past 10 years, recent changes in Indian law, which have introduced very, very punitive provisions, which are mandatory in nature, have forced judges to become lakir ka fakir. So if a judge thinks that, yes, this person has done something wrong, but I don't think he needs to go to jail for 10 years or 20 years, then that judge has absolutely no option. The judge does not have any discretion that the law provides that judge. The judge has to, find another offense which will suit. So here the judge has looked at, okay, POXO Section 8 applies, so please apply POXO Section 8. Do not apply attempt to rape, because that could be half of life imprisonment, which the judge might not be thinking is the appropriate sentence. Yes, the language and the reasoning used is really ridiculous. With all due respect, I absolutely agree with that. But this is something that we are seeing in cases. Judges are now more and more reluctant to convict in these kind of cases, maybe not because they think that the person did not actually do it, but because they think in their judgment that level of punishment is not proportional to the crime that has been committed. And this is happening all over. This is a systemic issue that our legislature as well as judiciary needs to be looked at. There is a judgment from 1836, which is quoted in judgment in this particular, the Allahabad High Court judgment. 1836. I mean, I was thinking about that there is a handbook on gender sensitive terms that the Supreme Court has come out with. But what about these really antiquated judgments? Now thinking has evolved. That person obviously was thinking from a mindset of the 19th century. We are in the 21st century now. Why are we not having some thinking around maybe do not consider these kind of judicial precedents, which are absolutely patriarchal in nature, which are based in a patriarchal way of thinking. And at the same time, when you are prioritizing conviction, do you absolutely need to have mandatory minimum punishments, or do you need to give some level of discretion to the judges so that they can actually decide, look at the facts of a case and decide that, okay, yes, this person has done something wrong. I want to put them in jail for 5 years. I don't want to put them in jail for 14 years or 20 years, etc. So, in fact, I would say that that is the systemic issue that the legislature and the executive needs to really look at if we really want to improve the system which is creating these instances, and these instances might keep happening. And of course, what you said about a patriarchal mindset, I think implicit bias training, trauma-informed approaches in judges' trainings, these things need to be introduced in the judges' curriculum. So yes, absolutely. That is absolutely needed.
Okay. Okay, Nimisha, I think you made some very good points. Rizwan, I don't have too much time on this debate, but I do want to touch upon something that that has been brought up in this very debate by Lalita ji. Essentially, the hint is that probably it's time for the NJAC, that the collegium system isn't working. Look at the kind of judges you are picking. They're delivering all sorts of verdicts, which the Supreme Court then has to come and rescue, etc., etc. Maybe it's time for the government to get involved in the appointment of judges. Do you think that will ensure that judges who have cash found in their backyard, burnt cash found in their backyard, and judges who think that grabbing a little child's breast and opening her pajama strings and pushing her to the ground are not is not an attempt to rape, that there'll be at least some degree of accountability.
Yes, but before I touch that subject, I want to just clarify one point, is that my learned friend pointed out the provisions of the new law which will not be applicable to this act which was committed prior to the introduction of the new law. So the prior act has to go under IPC and not under the BNS and BNSS. So I wanted to just clarify that part. Now, with regards to the other part that is concerned, that most of the judges that we find, who become subject to debates here on public platform, their orders or their conduct or XYZ, whichever, whatever comes before brings out one fact before the general public, is that probably the judges who are appointed in our country through whatever system are not appointed through a proper system, which will show that the judges are qualified, meaning not legally qualified or not professionally qualified, but qualified meaning to deliver impartial judgments in accordance with law, without any bias, without any prejudice, and without any kind of influence. So for this, I particularly think earlier we used to have jury system. We used to have jury system during the British time, which was taken out and which was thrown away. So now the judges, most of the judges, they feel that they are the master of that particular courtroom, and then they can do whatever they can, whatever they want to. And that is what is disturbing, because once you give so much of power, whether in the name of judiciary or whether in the name of adjudication, this is what is going to happen. If you have a prejudice or a biased mind judge, this is what is going to happen. So we definitely need to change the system, and we need to have a system where the public also gets involved, not only the politicians, because the politicians will appoint people as per their choice, because they want favorable orders. So we have to have public. The public has to be involved, like the system which was there earlier.
नहीं, तब तो बहुत confusion हो जाएगा. But we'll leave it there. I'm out of time. Thank you very much. Rizwan Siddiquee, thank you very much for joining us. Avishkar, thank you very much. Nivisha Srivastava, good to have you on the show. And Lalita ji, always good to have you on the show. Ladies and gentlemen, a quick break. I'll be back with more.